I've negotiated thousands of contracts over my career with a variety of different software vendors. What are the key items that you want to focus on when you're negotiating with software vendors? That's what I want to talk about today. My name is Marcus Harris. I'm a software and technology attorney for over 20 years. I've drafted and negotiated a variety of software-related contracts and litigated failed ERP projects in courts across the country. What are some of the key components in any software-related contract? Well, I think first and foremost, you're going to want to focus on either the scope of the license grant, to the extent you've got a legacy on-prem type of scenario, or the scope of the access that you're going to be allowed with respect to your utilization of a SaaS product. I think the first thing, who is the licensee, who is the user? That has to be identified with a pretty high level of specificity, because if you get that wrong, you've really got a problem. The next thing that you're really going to want to consider as you're negotiating who can use the software is what is the ability for you to allow third parties to access and use that software. Do you need independent contractors to utilize it? Do you need affiliates? Do you need partners? Whatever that scope of use is, you want to include it in that contract. And I always tell my clients this, and that is, you never have as much leverage with a vendor as you do when you're negotiating this contract right before you sign on the dotted line. So, to the extent you've got leverage, and you need to utilize it to include all of those things that are really going to give you what I would call, flexibility in your use of that product. And the goal essentially should be that you have all the indicia of ownership that you would if it was your product, and you've got all the associated flexibility to be able to avoid unnecessary expense and surprises down the road over the life cycle of that product in your organization. You want to make sure that you've got the right to access third-party products to the extent that they're bundled in with that software product. You don't want to have a variety of different types of things that are included, whether it's business intelligence, databases, but then have to execute an additional contract with a third-party vendor to be able to use that software. You want to understand really how the fee structure works, whether it's a licensing metric or just how revenue is going to be captured under that agreement. That's a pretty key provision. Is it user-based? Is it a type of user? Is it what kind of scope of use is going to be triggering revenue events? You want to understand, can I only use it at a particular site? Can I only use it at one location? Is it hardware dependent? Is it operating system dependent? If I want to shift to a different operating system in the future, is there a fee for that? All of these kind of mundane questions need to be asked, but the more vague that contract is, the more problems you are going to have. And the goal here is to put in place an agreement that defines what you can do and can't do with that software product with a high degree of specificity, so that you do not run into an audit issue. You don't have a revenue triggering event come up on you by surprise. You want to know the lay of the land. You want to know what you're getting into, and you want to be able to manage your relationship with that vendor by pulling that contract out of a desk drawer in a couple of years and say, okay, look, here's what we're allowed to do with the software. We don't have to pay you an additional fee because the contract already covers that. That's the ideal scenario you want to be in. So what are some of the other issues that you want to focus on in the contract? I think some of the simple things. What do you have a right to access? Okay, and what I mean by that is, is the software product described with some level of specificity? Is it accurately described? Because if you've just got the right to use a broadly defined term, Microsoft Dynamics, for example, that doesn't mean anything, right? It can mean whatever the vendor wants it to mean. And so if you've got to use different pieces of functionality, different tools, you want to be sure that is spelled out with a level of specificity in that agreement, so that everybody is on the same page. You want to have an understanding, certainly, of how much you're paying. You want to understand what the term is, the length of the initial term, how that contract is going to be renewed, and then some of the hot button issues in any of these agreements. Really, the warranty provisions. Okay, what is that vendor going to step up to the plate to and provide a warranty for? In some of the basic things that you should be seeing in any of these agreements really is some sort of a performance warranty. It's either going to be, well, let me take a step back. I mean, I think all warranties are going to be warranties of time, and they're going to be warranties of reference, okay? And so the warranty is going to point to some objective measure of performance, let's say, okay? So, is the software going to operate in substantial conformance with its documentation? That's a warranty of reference. Is the software vendor going to perform the services in accordance with generally accepted industry standards for like products or something along those lines? Those are the types of things you should be seeing in connection with the performance obligation of that vendor, and there should be one in there. You're going to want to make sure that to the extent that there's going to be any kind of maintenance services associated with the software support, that those very well may need a separate warranty that specifically covers those, or maybe it's rolled up into the broader warranty. You're going to want to have an understanding of when that warranty begins and certainly when that warranty ends. Is it the date that you signed the contract? Because that could be very problematic. I mean, if it takes you 2 years to implement the software and your warranty is starting from the date of execution of the agreement and it only lasts a year, well, it's pretty worthless to you because you haven't even used the software yet, and you can never make a claim on that warranty obligation. So that's something that you really need to focus on. You want to have an understanding of the scope of that warranty coverage, what is included and what is excluded from that warranty, what's reasonable, what's unreasonable, and we can certainly point you in the right direction. And that's probably a deeper dive of a conversation about the reasonableness of some of these things. But certainly, what is included, what is customarily included in a warranty obligation. Are they going to warrant, for example, that they've got good title to the software, that the software doesn't infringe? What's the scope of the territory with respect to that infringement? Is this the U.S.? Is it worldwide? Does that warranty of non-infringement or ownership, does it cover all types of intellectual property? Does it just cover patents or copyrights or trademarks? These are all questions that you've got to ask yourself. And then one of the key things with respect to a warranty is, what is the remedy that vendor is obligated to provide if it breaches any one of those warranties? What happens? It's all well and good to have a warranty obligation, but ideally, in my view, there should be an express contractual obligation to do something to remedy any breach of that warranty. That and the point is for that is that you don't need to run to the courthouse. You don't need to say you breached the agreement, and the vendor can say, okay, well, yeah, I did. Sue me. That's not a real tenable position, and you don't want to be in that position. So again, you want to say, okay, look. The software doesn't do what it's supposed to do, and if it doesn't do that, you're supposed to fix it. You get 3 bites at the apple, and if you still can't fix it, I get a refund and I can terminate the agreement. Something along those lines. You want to have a real tangible remedy associated with any breach of a warranty. One of the next hot button issues in these agreements really is indemnification, and there's different types of indemnification. There's kind of a general indemnification with respect to some sort of a breach of that agreement or a breach of an obligation in that agreement. Those kinds of indemnity obligations can go both ways. The software vendor may want an indemnity obligation from you in the event that customer data, your data, causes issues, gets them sued because it's infringing or for some other reason. You've got to make sure that the indemnity obligation that you're giving is reasonable, and you want to also make sure that you're getting a reasonable indemnity obligation from the vendor. They should have an obligation to comply with applicable laws. There should be some sort of indemnity obligation in the event that there's an infringement issue. There should be some sort of indemnity obligation to the extent that there is a data security issue. Ideally, and some of these things are going to be more negotiable than others, but you're going to want to make sure that you've got reasonably robust indemnity obligations that are going to provide you with a meaningful pathway in the event that you are sued for something that you did not do, which is the essence of what an indemnity obligation is. And I think, again, it's all in the negotiation of this. I mean, what's the monetary cap on that limitation or that indemnification obligation? If it's a multi-million-dollar lawsuit and the monetary cap on that indemnification is limited to the amount of money that you've paid the vendor for the software in the past 6 months, it's probably not going to be enough, right? In point of fact, you may not have paid anything for that software by the time that the issue giving rise to the indemnity obligation comes up. You may be only paying for maintenance and support on an ongoing basis. But the devil is in the details, and you've got to make sure that all of these things are addressed. One of the next big ticket items in these types of agreements, these software-related agreements, is really the term and termination. And I think you've got these perpetual SaaS agreements that many times will have an automatic renewal period unless you terminate it by the deadline identified in the contract. And you want to make sure you've got as much flexibility with that as possible. You've got to have an understanding of how the length of that term is going to tie into the fees that you are paying. I think if you're doing shorter terms, 1-year terms at a time, which is a little bit unusual, your fee structure is probably going to reflect that. If you're doing a 5 to 7 year term, you should be getting some sort of a discount based on the length that you're tying up or you're being tied up with that particular vendor. In addition to understanding how the term works, you want to be able to terminate it. Ideally, you want to be able to terminate it for convenience. You certainly want to be able to terminate it for cause. You want to be able to get out of that contract if there is a force majeure event. You want to detail what the triggering events for a force majeure event are going to be. And then you're going to want to have an understanding of what kind of termination notice do you need to give, who does it need to go to, what your obligations are upon termination. Do you have to cease using the software and give back all the proprietary and confidential information that's in your possession? You probably do, and how problematic is that going to be for you as an organization if there is some sort of termination event and you're not ready for it? One of the other things I think you want to focus on in connection with termination is really something I would call transitional use rights. Okay, it's going to take you a long time to select an alternative software provider. It's going to take a long time to get that software system up and running in your business, and you want to make sure you have some sort of residual access or some overlap with the software you're using to run your business. You don't want to just have the vendor turn it off and then you've got no rights. And again, this is a matter of negotiation. If you've got transitional use rights, that's great. Do you have to pay for them? You might have to. So, there's a variety of considerations in connection with term and termination. One of the other issues in these agreements is really the scope of a confidential information obligation or confidentiality obligation in connection with proprietary information. You're going to want to make sure that the obligations are reasonable, that they are mutual, most likely. If the vendor is going to be having access to your confidential information, they usually do, and you're going to want to make sure that any obligation you have to keep that vendor's information confidential is reasonable as well. You're going to want to have an understanding of what the definition or the scope of what constitutes confidential information is. You're going to want to understand the standard of care that the parties are obligated to take with respect to that confidential information. You're going to want to think about how long your obligation of confidentiality is. Is it for the duration of the contract? Is it going to survive the termination? If it does survive, how long is it going to survive? You don't want to have some perpetual obligation of confidentiality that runs forever. That just doesn't make a lot of sense. Can you disclose any of that confidential information to third parties? Do you need to return that information or destroy it? Is there a certification associated with that? So there's a lot of things to consider in the context of what the confidentiality obligations are in these contracts. The next issue I'd like to talk about is limitation of liability. Okay, and this is a hot button issue all the time, and you don't want to agree to an agreement or a contract that subjects you to unlimited liability. That is a scenario that if there is an issue that could potentially put you out of business, you want to know what the parameters of your risk, what the risk is with respect to your business relationship. You want to be able to mitigate that risk, understand it, and having a reasonable limitation on your liability is one of the ways to do that. Again, you want to have a mutual limitation of liability, most likely. You want to cap the amount of direct damages that you would have to pay. What's that cap? Well, it could be fees paid. It can be a multiplier of fees paid. Usually you don't want to have some subset of the contract term, though the vendor is going to want to have something similar to that. You want to have an understanding of what is excluded from that cap with respect to unlimited liability. Is the liability for an indemnity obligation capped, for example? Is the a breach of confidentiality, is that going to be capped? If there's a data security incident, what's the cap on that liability? So all of these things are issues that you need to pay attention to. There's a variety of other issues. I mean, I think you want to look at source code escrow issues. You may or may not need that. It just simply depends. You're going to want to look at some of the more, I think, boilerplate obligations in these contracts. And what I mean by that is you're going to want to look at things like assignment provisions, right? Do you have the right to assign that contract? Some vendors will try to slip in some sort of a payment obligation so that you can assign that contract. Or if you want to assign it, you've got to pay them. What's the governing law? What is the venue? Where are you going to litigate that contract? Is that contract subject to litigation? Is it subject to arbitration? Is there a mediation provision in that agreement? All of these things are going to be negotiable, and all these things are issues that you need to pay attention to. You want to think about, in the context of miscellaneous issues, you want to have an understanding of what happens if that software vendor goes bankrupt. You want to have an understanding, and we talked a little bit about it, but the force majeure events, those are all key issues with respect to these software agreements. And then how are implementation services going to be covered? Is that going to be covered in the same agreement that you're getting the software under, or is that going to be in a separate agreement? Ideally, you'd have those two things separated, because I think the warranties and representations and IP infringement landscape is a little bit different in the context of implementation consulting services than it is going to be in connection with the provision of services. So you want to know what the scope of the consulting services are, where are they going to provide them, who's going to be providing them, is it going to be, are they going to subcontract that out? Is there more than one provider of implementation services? If there is, how is that going to be coordinated? You want to make sure that you've got some sort of discount on the fees, cap any kinds of fee increases in that implementation agreement. You certainly want to make sure that there are substantive, detailed statements of work. You want to see project plans attached. You want to make sure that there are milestones and deliverable obligations. You want to make sure that if deliverables are non-conforming, that there's an obligation to fix those deliverables. So I mean, there's a lot to consider in these agreements, and certainly any kind of discussion like this has got to be a little bit at a high level. But to the extent that you've got any issues or questions about any of these topics, you're negotiating an agreement with a vendor, feel free to reach out to us. We'd love to talk to you about it, get you pointed in the right direction.